Hey everybody, we are going to start with Digital Law and Legislation, Chapter 10. So, uh, this can be a quick overview of the federal rules and regulations that govern computer crime. Uh, I need you to read the book. I want you to look at the case law. I'm just going to reference the case law in the PowerPoints. What I'd like you to do is actually read through the case law in the books itself. All right, so at the end of this, you should be able to explain the intent and fundamental concepts of search and seizure, identify situations where search and seizure is possible without a warrant, describe the federal statutes that govern electronic surveillance and communications networks, discuss the issues presented regarding the admission of digital evidence at trial, and then identify and discuss the significant U.S. Supreme Court cases focusing on cybercrime and evidence. And that you're going to do on your own. I'm going to give you a list of cases, and they're in the book, and I want you to make sure you read through those cases because they really give you an understanding of how the laws were changed by the case. Okay, so the current body of search law, it's an ongoing thing. But there are some tenets that have been ground constitutionally through case law, etc. I guess the first thing you really need to remember is when we talk about case law, it's very important that you follow the entire case law. During the course, questions always come up. Well, why can't we use case law in our papers as empirical evidence? A judge says so. Well, that's a judge's opinion, as we've talked about. Case law has to be followed. So when you talk about search and seizure law changes. So Georgia passed a statute saying that cell phones could be examined. Immediately after that, that was held up by the Court of Appeals. It was then overturned. So if you read the first ruling, you would think that it was legal to just search phones in the state of Georgia. But if you follow through the law, you find out that there was an appeal, and then it was overturned later on. So it's very important to remember that you have to follow the law all the way through to its conclusion because it will change as it goes. Search and seizure law has been seen not to keep up with computer crime. And it also is challenged a lot by the Fourth Amendment. Computer crime is difficult because of the nature of the way we possess the objects. They're a lot more. A phone is more like a wallet or a purse for most people. Things in there are seen as private. They're not open containers. They're usually pass locked or pass coded. So the search and seizure law has really struggled to move from kind of the physical world things into this new digital container. What is a container? Who owns it? Who has access to it? Et cetera, et cetera. So that's one of the problems with the search law staying current is as it does catch up, unfortunately, new things have come in place. We're dealing with AI now. How do you investigate an AI case or someone that's chatting online with an avatar? Do we have to investigate the avatar? Can we seize the avatar? Does the avatar have any relevance? Things such as that. And these are all questions that are going on today. One interesting concept that we're actually I've written a couple of articles about is the use of the Alexa speaker as a digital deity. So at some point, somebody's going to look at that device and say, you know what, that is my God, that is my church, that is my pastor, and everything I said to it is protected speech. Well, the law says no right now, but that law may change, and at some point, all of that information that I'm talking to my speaker will turn into protected because my belief is that the speaker is a God. The speaker is a intelligent thing that gives me answers to my questions. There's actually been worry about that in the Catholic Church as they put a letter out to all of the bishops and priests and said, you need to be really worried about people asking advice from their speakers instead of talking to you. So they're absolutely, it's something that is coming. And the search and seizure law is just not ready to deal with that yet by any means. All right, so we have two terms, search and reasonable. Reasonable search means things that I can look at that would make sense. Again, we're going back to the shotgun in a pill box. If I open a pill box and the court says, well, you were looking for a shotgun, I say, yes, but I looked in the pill box because you never know. It may have been shrunk down and put in there. That's not reasonable to the court. Search and seizure law is not to protect criminals. It's to protect a person's reasonable expectation of privacy from the federal government. Okay, the search and seizure was put in place to protect you, the citizen, from the government. When I remove your property, if I'm law enforcement and I come in and I take your property, if I'm doing it under search and seizure, I'm actually taking away your constitutional protections. If I came in as a normal person and took your property, it'd be theft. So what's the difference between theft and seizure? Well, the court says that I can seize property for a legitimate reason. This is all in that search to provide objects or artifacts that are going to be used against you in a court hearing later on. So there's a lot of concern when it comes to search and seizure. There's a lot of people that have spent years and years and years studying search and seizure, and it ebbs and flows in its interpretation, and especially when it came to the new cell phone search and seizure rules. They were kind of all over the place. California had rules, New York had rules, and Georgia had rules, and everybody kind of fell in the middle of those larger districts passing laws on cell phones. So search and seizure is fluid. I guess that's the easiest way of summing that up. So a search warrant is a piece of paper that is issued by a judge. I have to show probable cause. I have to do an affidavit to the court, and I have to explain why it is that I want to go into your house. I can't just call a judge and say it's because, I have to have some concrete evidence. Sometimes it can, depending on the judge, and you hear people you hear people say they're judge shopping, because there are judges that are a little more lenient than others, and some judges are very strict with the law. So it all depends on the judge. And you can sometimes get a search warrant from one judge when you know for a fact you wouldn't get another judge to give you a warrant. So that's a way the system kind of gets played sometimes. And you have to, but no matter what you do, you have to meet these three basic criteria. The crime's been committed. There is evidence of that crime, and that evidence is in the place that you want to search. So when you talk about computers, you kind of run into a problem there, because if the evidence resides on a cloud storage, it may not reside on the computer. What's your nexus to the computer if it's stored somewhere else? And the computer law really has a challenge when it comes to this environment where everything is stored in different locations. The search and seizure law is really good when you got a shed, and inside the shed you got a stolen tractor. But when you've got that shed and it's in China and the tractor came from the Netherlands and it's being opened by a guy in Ohio, yeah, you got some issues jurisdictionally, and just across the board, dealing with other nations, dealing with the State Department, because you've got to have them send your request for search to another country. And then the court, again, the judge is the one that's actually going to sign it. In fact, there's something that not a lot of people know is we use the word evidence a lot, and it's it's a term that we use loosely, but evidence actually doesn't exist until a judge actually admits it into court. When a piece of or an artifact comes to the court, the judge looks at it and says, yes, that was collected correctly, it's relevant to the case, and now I'm going to let that be a part of the evidence against the suspect. The judge may easily say, nope, it's not relevant, doesn't have any bearing, so that is not going to come into court, and it's not evidence. So we use the word evidence to kind of as an overarching thing to talk about everything, but in actual fact, evidence does not exist until a court says it's evidence. If you have a flawed search, you're going to lose your evidence. Okay. You also may, as a law enforcement officer, you may actually have civil liability for taking something that you're not supposed to take. There is a good faith doctrine, which is a defense of flawed, which is, I believed I was doing the right thing, or I thought the search warrant had that on there. There's all kinds of little excuses, but the bottom line is if you have a bad search warrant, you do a bad search, you violate the scope of your warrant, you're going to lose the evidence more than likely. Exclusionary rule applies to improperly obtained evidence, and exclusionary rule means that the court is not going to allow that artifact into evidence. It's called the fruit of the poisonous tree. You can look at map v. Ohio. And it was designed to curb police abuse of civil rights and also to stop police misconduct. For example, I would go into a house and I would hold a guy up against a wall in a chokehold, and I'd say, do you consent to me searching your trailer or your house or your car or your RV? And the guy would say, yeah, absolutely, you're going to choke me out. And the police would search the house, and sure enough, they'd find something, and it was a consensual search because the guy gave consent. Well, obviously, we know now that you can't go in and put a chokehold on somebody, but that used to be how law enforcement got to some of the evidence they got. And this is back in the 50s and 60s, and intimidation was an easy way of getting someone to comply. Putting something in a car that then makes it plain sight doctrine, that then I say, oh, look, there's something here, so I'm going to search the rest of the car based on that. That was something that happened quite a bit. And a lot of this stuff had to be curbed. The courts, weren't having it. And they got rid of a lot of this abusive conduct by the police. The exclusionary rule has a couple of defenses. One, an independent source with the same information can redeem the evidence. So let's say you have tainted poisonous tree or evidence, and the judge says, nope, absolutely not. Well, there might be an independent source. So you may have another investigator that found another lead that leads to that piece of evidence and can redeem that evidence through the legal process of seizure by their investigation that's independent from your investigation. So let's say I'm a local law enforcement officer and I violate the rules. An FBI agent following the same, doing the same case or following their leads, not the same leads, but following their leads, may find another lead that leads to the exact same evidence. That evidence can now come into the court because it's now no longer tainted by the illegal search. There's also one known as inevitable discovery. Okay, inevitable discovery is something that would have been found no matter what. Let's say we're going back to the shotgun rule, and instead of it being a small box, let's say I found something in a closet when I was looking for the shotgun, but it wasn't the shotgun, it was something else, maybe drugs or something else. And they say, no, that you were looking in the wrong place. Well, you could also say, well, inevitably I would have opened that closet door looking for that shotgun. So no matter what reason I opened that door, I would have seen that other evidence, or that other thing of a legal nature. So inevitably I would have seen it looking for what it is that I'm looking for. So my trail would have led inevitably to the discovery of whatever object it is that we want to bring into court. And then the judge may agree with that and say, yeah, if you're going through servers and you're finding things in common places, inevitably everybody would have found, or anybody would have found, that you didn't really violate anything. You were in basically either plain sight, or you had some other reason to be in that area, and you happened to come across the other piece, which inevitably would have been discovered. A lot of searches done by police do not involve a warrant. There's a lot of warrantless searches. Stop and frisk, for example. This is a very controversial policy that's done in larger cities, where people are stopped and frisked because of behavior, because of crime rates, etc. Consent search. A consent search may happen where I go into a dwelling and I say, I want to look at your computer. Do you give me permission to look at the computer? And they say sure, and they give me consent to look at the computer. This has happened several times. Now, one of the things about consent search, especially where we were at the Sheriff's Department, if someone gave consent or there was consent for a search, we would whip out a piece of paper and it would lay out, this is a consent search, you are not being intimidated. It would give them all of their rights. They would read down the whole thing and they would sign the consent search. So later on when they said, well, I didn't give consent, we could pull out the paper and say, yeah, you did. And here's your signed consent saying that you did allow us to conduct that search. And then we have exigent circumstances. Exigent circumstances may be caused by some type of environmental issue. For example, let's say you had a body or you had some materials that were on the water line and the tide's coming in. The tide's going to destroy the scene. So there have been times where they've picked the scene up and they've moved it back 6 feet and laid the scene back in exactly, the objects back in exactly, and then searched through those objects. The initial gathering of those objects is a search because I'm going through and I'm grabbing all that stuff to move it. But I'm moving it for an exigent reason. There's something that's going to destroy or cause harm. Exigent circumstances for the folks I teach out in NATO happens all the time. You're on a tactical battlefield or a tactical crime scene and you're getting shot at. You don't have time to always follow every procedure, filling out bags and filling out chain of custody right there. You may have expedited methods of collection which aren't technically going to be used or allowed in a normal situation, but the court can say, you know what, we understand you're getting shot at, and when you did get out of that situation, you did stop and correct the paperwork to reflect what happened at the scene. Search incident to arrest. I arrest you and I pat you down. Plain view. I look in your car and there's something to see. Border searches, and then searches by private citizens. And we're going to go into these in a little bit more detail here. But these are all examples of warrantless searches. So stop and frisk, it's possible to identify source of digital evidence during a stop. So I might find, I'm looking for weapons and I'm looking for narcotics. That's really what I'm looking for in a stop and frisk. It does say here, like it says in the law, it is possible that you will run across a device. But I can tell you right now, if I find a thumb drive on somebody, it's going to be really hard for me to justify taking that thumb drive to say that that person was going to cause harm unless they have something on them. Now, if they have a weapon on them and they also have thumb drives, well, one, we're going to identify the person by the weapon, and we're going to, they're going to get stopped. They're going to get arrested. So the search incident to the arrest is going to now collect that thumb drive. Okay. If you do find a thumb drive, for example, and you really don't have any reason to go into that thumb drive, there's nothing there for that thumb drive. You can't whip out your computer, throw the thumb drive in just to see what's on it, because you're going to lose that in court. Um, that's a very clear. Stop and frisk has been abused for many, many, many years, and all kinds of evidence has been thrown out at the court level. When the court, basically laid the litmus test down and said, "Well, what were you afraid of? What was your fear in this stop and frisk?" Consent searches, like I said, they happen a lot. Uh, Consent to your property is fine, but I can't consent to somebody else's property. So you go into a dwelling and we have two roommates and his room is locked, and I say, yeah, go ahead, you can search that. They can't search that. That doesn't belong to that person. He has no right to give consent to search that other room. I can give consent to those things that I have ownership on. And this gets kind of tricky when we start talking about computers, because you may have profile-based computers, and those profile-based computers may not allow me to access certain things on the computer. Exigent circumstances. Like we talked about, I may be in a situation where I have the right to be there, and I am going to do everything I can to either preserve the evidence I'm collecting from being destroyed, or I have some thing that's going on or something that's going to happen that may destroy the equipment. For example, in computers, I may have a fire. So I might search the bedroom looking for digital components to prevent them from being destroyed by the fire. Things such as that, something that's going to cause problems. Or let's say that someone has an encryption key inside the side of their computer. I may provide, or I may take them down in a way that the encryption key can't come out of the computer, so that I can do a search using the computer while it's still turned on. Technically, I'm providing or keeping the key in the door so I can do a search. And it's been held that if the key stays in the door and doesn't fall out, you're okay. So that's one method of, or one thing that we want to make sure is we want to keep the key in the door, especially on encrypted drives. And you're always going to have to prove your exigent circumstances. The law enforcement officer is going to have to articulate to the court why they did what they did. Incident to arrest, officers are allowed to search you for incident arrest, and they can also do an inventory search upon arrest. They can take your phone, they can take your belongings for safekeeping. Does not mean I can search that phone. It means that I can seize that phone, but it doesn't mean I can search the phone. So let's say I stop you, arrest you, I do a search, find the phone. I'm going to put the phone in an evidence bag, and then we're going to get a court order to search that phone. But I still have to have a reason to search the phone. If your crime has nothing to do with the phone, then I'm going to have a problem explaining to the court why I need to search your phone. Plain view doctrine, Kylo versus United States. It's lawful to seize things that the officer can see in plain view. So if I walk up and I look through your car window and I see dope sitting on the back seat, you know what? You're going to get arrested. And you're going to be charged with what I saw in my plain view doctrine. Now, if I walk up to someone on a computer and I see something on the screen that I identify as something illegal, I can seize based on that. I can search or get a warrant to search based on that. So, the plain view doctrine still applies in, computer crimes, but it's a little different. I have to see the device on, for example, and I have to be able to see something that I can identify later on and articulate to court what a plain view is. Like a thumb drive, I couldn't just look at the thumb drive and say, hey, Your Honor, I know that there was pictures on that thumb drive because all thumb drives have pictures, so therefore I seized it. It was in plain view. Well, the thumb drive's in plain view. The pictures are not in plain view, so you're going to have an issue explaining why you seized the thumb drive for the pictures. There's other ways of getting that thumb drive, but plain view is not going to be the way that I get that evidence, unless it is a specific thumb drive on a specific search list or wanted list or a stop and hold list, and they have a purple thumb drive with red lettering that says secret on it, well, then you have the right to seize in plain view because you know that you're looking for that specific thing. Okay, and that plain view would apply there. You still can't go into the thumb drive, but you can certainly look at or take the thumb drive into custody. Border searches. Border searches, they don't rely on constitutional protection. Border searches are the most expansive of all searches. You don't have the right coming across the borders to say no, basically, to a search. If you are requested to be searched and you're coming across the international border, the law enforcement can do whatever they need to identify things that would harm people in the nation. That could be drugs, that could be criminal activity, that could be many different things. It's very broad and very expansive. U.S. versus Roberts is a great example. Another great example was a child pornographer coming across from Canada to the United States. The Canadian Border Patrol actually saw images on his laptop that was in his vehicle, recognized him as being child pornography. As soon as he got across the American side, they called. The American border agents arrested him and seized his property based on the observation of the Canadian Border Patrol or border agent. So border searches are very expansive. If you're coming across the borders, anything you have can be searched. It's the right of the government to protect the nation. Searches by private citizens. So the silver platter doctrine allows evidence collected by members of the public to come in, and this was abused heavily with private investigators. And the courts really frown upon using the public for searchers. So they came up with something called the agent of the police. And if you become an agent of the police, everything you find is going to be thrown out because you're no longer working for yourself. You're now working as an agent of the police. If I'm just a member of the public and I come across evidence and I turn it in, that can be used. But if I'm a law enforcement officer and I say, hey, you should really go into this room and see if you can find this for me and then bring it back, and they do, I've just made you an agent of the police, and that search is illegal. You have some people say, well, what if the person commits a burglary and finds evidence? You can absolutely use stuff that was committed in the commission of that burglary, because they're going to get charged with burglary, and then you're going to get the evidence that they retrieved. There's been several times where diamonds and other precious metals have been found in someone's house that were stolen, and that led to that person being convicted for stealing the diamonds or the stuff, and the other person being found guilty for stealing from the person that stole the stuff in the first place. Gets a little complicated sometimes. Two federal statutes that govern the practice of electronic surveillance. So now we're kind of switching from search and seizure. Now we're talking about a very specific part of the law called tap and trace. Trap and trace are the ability for the government to listen to your communications. Okay, we have the Omnibus Crime Control and Safe Streets Act of 1968, which gave the government the right to listen to certain things. So a Title III warrant will allow me to listen to your communications, record your communications. And then we have pen registers and trap and trace devices, which are connected to equipment that allows me to monitor incoming, outgoing phone calls, digital transactions now, things such as that, and that all falls under Title 18. The pen and trace statute regulates the collection and the types of things that you can collect under a trap and trace. The law is sometimes misused by law enforcement. sometimes out of ignorance and sometimes just because they don't think they're going to get caught. But there is a lot of abuse in the tap and trace rulings. The statute has been applied to the computer network communications, not just telephones. So now I can do cell phones. But a lot of law enforcement agencies have gotten into trouble. There's a sheriff's department in Florida that was doing tap and trace on a community, and basically they were gathering everybody's communications, and they were actually trying to find a suspect in one court case, and they ended up listening to a lawyer in the sub community talking to a client about something that was going on, and then they tried to use that in court, and everything got thrown out, and their ability to do tap and trace actually got suspended. It's still suspended in that county in Florida today because they abused the trap and trace statutes, and the court was very, very upset that this sheriff's department used a tool, a very expensive tool, to gather all of this information. Courts can authorize tap and trace up to 60 days, but it can be extended. So if I have a tap and trace, I've heard from folks in the federal side, some friends of mine have told me that they know of traces that have been going on for 8-9 years, collecting information on specific threats or threat target locations. So tap and trace can be extended. It just takes a court order and a judge to approve it. Title III regulates the collection. Title III contains numerous exceptions, including exception pursuant to Title III order is a consent exception. In other words, one of the persons on the phone call makes a consent statement. So let's say you're talking to law enforcement, and I say, I consent, I'm law enforcement. I can now record that conversation. Provider exception. So providers that own equipment can monitor and track people that are on their networks or within their networks that are doing something illegal. And then computer trespasser exception, where if you have someone in your computers, say you have a hacker or something like that, and the provider or the person starts trapping and tracing the communications, they can be used in court. Extension telephone exception. This was created back when we had extension telephones, but it still works today. Using extension telephone, a recording can be made off the extension telephone instead of off the actual phone itself. Inadvertently obtained criminal evidence exception. So you may be doing something else and you come across evidence that leads you to another crime or the furtherance of another crime. You can absolutely use that in court. And then the accessible to public exception. If I can get it through public records, then there is no records. And some of the things that fall into that today are CDR records, call detail records on cell phones and towers, because they're becoming business records, and I can now request those business records. All right, so ECPA regulates how the government stores and, how the government looks at ISPs that allow communications. There's two components that are created under ECPA, the Electronic Communication Service, and this is going to be your service that allows the transiting of information across their network. They don't store or open anything, they just allow transiting. So this is going to be larger ISPs, routers, hubs, switches that belong to outside communication structures. And then you have the remote computer service. This is the place that maintains the email or objects that you are working with on the network. So a remote computer service is going to be your mail server, MMS, SMS servers. Could be a Twitter container. It could be many other social media style containers, remote storage containers. These can all be remote computer service. And ECPA covers those categories of computer service under the Electronic Communications and Privacy Act. You've got to show information that gives cause to go in and collect information. So if I'm going to go to Dropbox, or if I'm going to go to Microsoft OneDrive, I got to have something that shows clearly that that individual had access from that computer that I'm interested in to that container that's being maintained. Now, I can do that through account information. I can do that through many different means, but I've got to show some reason why I have access to that container. The Patriot Act, it came in after 9/11, and then we have the USA Freedom Act, which came in right after it, which kind of took over for the Patriot Act in a lot of ways. These acts gave a lot of freedom to pursue terrorists. Now, you're probably thinking, well, okay, so that's terrorism. Absolutely, we want to have more rights. The problem with it is, like everything, it was seen as also a way of getting around the rules on certain other things. So if I throw the label of terrorism on something, well, now I have greater latitude for collection, seizure, wiretaps, all kinds of other stuff, because the judicial oversight is not as strong on those. Okay, the wiretaps are normally provided in a secret court, and you obtain your court, or you obtain your warrant, and you can do your wiretap. And it has been found that they are not as well managed as other types of wiretaps. So terrorism, if you've noticed over the last few years, everything is terrorism. If there's a shooting, it's terrorism. Throwing it into the bucket of terrorism gets you into the Freedom Act or the Patriot Act. So classifying everything into terrorism allowed for the federal government much greater access, much greater latitude in the collection of evidence under search and seizure. CALEA, which is the Communications Assistance for Law Enforcement Act, this came out to require and force ISPs to have a way for law enforcement to connect to that network with some type of surveillance tool so they could do surveillance on those networks. The FBI had a tool that was placed in ISPs around the country for a while. That kind of went through its day, and it finally stopped. But that program yielded a lot of good. It found a lot of child pornography and a lot of criminal activity, and it did some real good. So CALEA was an act that forced ISPs that were typically very resistant to having law enforcement in their server rooms, required them to provide access and availability to be able to connect and install hardware, software onto servers for tap and trace or other collection methods. 3 federal crime statutes focused on computer crime. It's going to be your Computer Fraud Act, Espionage Act, and the Copyright Act. These are acts that regulate and control our ability as federal law enforcement and local law enforcement to be able to obtain and extract certain types of records. The Computer Fraud and Abuse Act, it's primarily an act that looks for unauthorized use of networks. It protects computers that are connected to the network. And this is what you're going to be charged with if you hack. If you hack into someone's computer and you don't really do any damage, but you actually go onto someone else's property, you computer trespass, you're going to go under the Computer Fraud and Abuse Act. The Computer Fraud and Abuse Act is a pretty wide and ranging act, and a lot of people will be very surprised at things that you can be held under in the Computer Fraud and Abuse Act, such as changing your name on a Facebook to a name that's not yours, or changing your age and putting a different age, or lying about your place of birth. those are all lies on the network, which actually fall under the Computer Fraud and Abuse Act, which could get you in trouble with the federal government, because it is illegal to lie on social media networks based on the rules and regulations of the social media networks. All right, Economic Espionage Act. The primary purpose of the Economic Espionage Act is to stop people stealing our trade secrets. This is something that is it's in the news today. We're constantly talking about it, but it applies worldwide. We have agreements with other countries that wanted to be a part of this agreement to enforce the theft of trade secrets and intellectual property. And that can be done through physical or electronically stored communication. So I could go in and steal plans and documents in a folder, or I could steal a thumb drive having those plans and documents. Either one of those would fall under the Economic Espionage Act. The Copyright Act, you probably have all read the Copyright Act at some point. It comes on the end of DVDs and videos and other stuff, and I'm sure you have sat there and watched the FBI warning and read all the things about copyright, and you know that copyright infringement is an illegal activity and will get you in trouble. But not a lot of people have read through all the things that they sign. You may sign, or you may check that I understand little block, the EULA, the End User License Agreement that comes with most of your applications. And instead of reading through all of that, you just assume that it's just normal lawyer language, and you sign off on it. The problem is, a lot of times you're agreeing to things that you don't realize that you're agreeing to. For example, in the old Microsoft Office applications, by checking or agreeing to the EULA, you actually gave Microsoft authorization to come in and audit your computer at any time. And not a lot of people knew that. And once it came out that was a part of the EULA, there were a lot of lawsuits, and there was a lot of changes to Microsoft's EULA to remove that provision. So the Copyright Act, it enforces enforces copyright, prevents people from stealing intellectual property. But the Copyright Act is a U.S. thing, and that's something else you need to understand. Copyright Act, there is an international copyright, there is an international board for it, but copyright enforcement really is a U.S. and EU thing. Outside of the U.S. and the EU, it's kind of not looked upon as much gravity as you would think. As we moved into like the YouTube era, where we were posting videos and doing all that stuff, we had to come up with the Family Entertainment Copyright Act. It makes it illegal to record and photograph or otherwise copy motion pictures, because what people were doing is they were taking that and they were throwing that up onto a YouTube. So you would find full-length videos and movies that were copyright protected that were on YouTube or other mediums, YouTube being the number one. That's why I keep mentioning it. So they had to come up with this new act, the Family Entertainment Act, to prevent people from doing nefarious things with copyrighted material using a channel like YouTube, which allows you to put up full-length movies, copies of shows, things such as that. All right, so admitting evidence at trial. So when a computer comes to trial, it comes in as computer-generated records and computer-stored records, okay? So computer-generated records, they have some authenticity, okay? A computer-generated record is a log file. It's something that is produced by the computer, and it's really hard to say that computer had some intent to change or manipulate the records to make someone look guilty. So there's some authenticity that comes with the thing. There's an implied trust that come with computer-generated records. But But computer-generated records can be flawed. If the time and date is set incorrectly, if there's other things that are misaligned on that computer, the authenticity of those records can come into doubt. And so it's a double-edged sword. It does have authenticity, but that authenticity is also sometimes the way that people get out of things because the records are not maintained correctly or the system administrator didn't set up the logging correctly. And then computer stored records, these are things that we put onto the computers, okay? The files that we have, and they can fall under the hearsay rule. You may allude that I put them on there, but you can't really prove that I put them on there. Or you may hear something, but you don't know exactly what it meant. There's no context to it because it is a computer-generated record. So in the authentication, some of the challenges that you're going to get when you're dealing with authentication is were the records altered, manipulated, and we have ways of protecting that. So with computer-generated logs, we have ways of looking at the server records and proving that they were there. So we have authenticity there. The reliability of computer program that generated records. If it's the operating system, we have some authenticity there. We have some authentication there. If it's third party, then we have to explain how that system actually works. And then questioning the identity of their author. So you're going to go after Microsoft. You're going to go after the producer of the software, saying that they had some reason to help you commit the crime or change the records. The hearsay rule exists to prevent unreliable out-of-court statements by people by influence outcomes of trials. When a computer record contains assertions, the record can contain hearsay. So here we have things where someone might make a recording. You may have other records that are used on the computer to say a person did something. And these can all be a part of the hearsay rule. There is a business record exception. We talked about business records a few chapters ago. And the business record exception basically says that logging files, server-based files, things like that, these business records, these things that really have no intent or bias built into them, can be used in court as an exception to the hearsay rule. So the best evidence rule states that to prove the content of writing, recording, or photography, the original writing, recording, photograph is originally required. Okay. In the computer world, best evidence is to image that item and make an exact copy of that item for your exploit or for your analysis or exploitation. This is the best rule of evidence in computers. You can't do it with DNA and blood. You can't reproduce blood, but you can accurately reproduce a computer component or drive. The storage can be accurately copied from one medium to another medium, and then that medium can be used as evidence in court. The original evidence can be put back into the evidence room. It has to be stored. You have to maintain the original evidence, but you can use that mirrored copy. And in fact, in this class, you're going to go through a file that is a imaged copy of a computer that you're investigating, or one of the computers that you might be investigating. That image file is what we would use as our best evidence rule with the tool that you're going to be given to do the investigation. All right, so we've covered a lot under search and seizure. Again, the federal crime statutes, they change not regularly, which is a bad thing. It does take a while for things to change. It's kind of like the Titanic making a U-turn. It takes a while. The court cases that are listed here, these are kind of the cases that laid the foundation for all of the things that we're talking about. Katz, Florida versus O'Reilly. Steve Jackson's game case is really one of the foundation court or cases that set up search and seizure, especially when it came to the computers. Steve Jackson Games is a very interesting read, so I really recommend you read that one if nothing else. So go through these cases in your course readings. Make sure you understand the premise of the cases and why those cases were produced the way or had the outcome the way they did, and then see how they apply to the different acts that came from those court decisions or these court decisions. All right. Okay, so let's say the end of this slide set. Make sure you read the book, dig in and look at your court cases, look at the sidebars. Lots of good information in that book. Again, the slides for this one are very strategic. We're going across the tops of the waves. I'd like you to dive into the waves and look at some of the stuff in the book. All right. So with that, I am going to say goodbye, and I will see you in the next slide set.